Good afternoon, everybody. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Forced Resignation versus Constructive Dismissal. My name is Ryan Cheong, and I'm an associate with Ma Wing Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Associates is a mid-sized law firm, which was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises of 27 lawyers and a support team of 21. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, an employment department, and a dedicated focus on servicing the needs of individuals and families. Our practice group indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013. Some of which were also broadcasted live. But with the COVID-19 pandemic, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 16th talk in our online talk series in 2022. Before I continue, please be reminded that this talk does not constitute legal advice, and in the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details of this will be given at the end of this talk. Before we continue, I would like to introduce our speakers. Today we have two speakers, the first being Naveen Joshua Solomon. He is a senior associate in the Employment and Industrial Relations Department, General Litigation, Contractual Disputes, and Debt Recovery. Our other speaker for today is Carolyn. She is an associate in the General Litigation Department, the Intellectual Property Department. She does employment disputes and also strata management disputes. Our first speaker of the day will be Carolyn, and I'll be handing over the floor to her. Carolyn, over to you.
Thank you so much, Ryan. Good afternoon, everybody, and thank you so much for joining us. Thanks again, Ryan, for the kind introduction. For today's talk points, I'll be going through, firstly, with everybody, the difference between constructive dismissal and forced resignation, as well as going through some case studies for forced resignation. I will then be passing the floor over to Naveen, who will go through some case studies for constructive dismissal and then wrap up with how to avoid both types of claims. Going first into constructive dismissal and what it is. Constructive dismissal is said to happen when an employee walks out of their employment willingly themselves because of actions that have been done by their employer. This is usually when the employer does something which is considered to be a repudiatory breach and then fails to address the actions, which leaves the employee with no choice but to leave their employment. In order to prove constructive dismissal, there are several elements that the court will take into consideration. These elements were mentioned in the case of Western Excavating. Here, we have the quote that was mentioned by Lord Denning. It says, if the employer is guilty of conduct which is a significant breach going to the root of the contract of employment, or which his conduct shows that he no longer intends to be bound by one or more of the essential terms of the contract, then the employee is entitled to treat himself as discharged from any further performance. So as we could see from that quote, first, there needs to be a breach by the employer. This breach needs to be sufficiently serious and important to justify the resignation. The employee must be seen to have left because of the breach by the employer and not for any other underlying reasons. And finally, there cannot be any delay in terminating your own contract. Because when there is a delay and you want to claim for constructive dismissal, the issue arises that the courts will consider there to have been a waive of the breach and you are deemed to have accepted it. So as I mentioned earlier, in order for there to be a successful claim in constructive dismissal, the employer's breach must be serious and go to the root of the contract. It must be so bad that the employee cannot reasonably be expected to go on with the contract. Once the breach has occurred, it must be shown that the employee has given the employer sufficient notice. This is to give the employer a chance to fix the breach or address the issue. Must show that at least there is a discussion of some sorts, as long as the employee has put the employer on notice. Looking now into what kind of breach needs to occur. So previously, it was only if there is a breach of the express terms of the employment agreement, things such as non-payment of salary. However, now it is extended as well into implied terms. This is because the court now recognizes that there is a relationship of mutual trust and confidence between the employer and the employee. You as an employee can reasonably expect, you trust that your employer will act in a manner, provide you with a safe space to work, conducive environment, and things like that. Therefore, now you can also claim, a constructive dismissal can also be claimed where the employer has frustrated the employee to the point where the employee sees no other option than to leave. This was mentioned in the case that has been stated there, Stanley Ng Peng Hon, making a workman's life so intolerable as to force him to resign. So here we have a list of examples where a list of examples of an express breach of the employment agreement, things such as unilateral deduction of salary, demotion, non-payment of EPF and salaries, non-compliance with fundamental terms of the contract, and transfer out of the company. Okay. And here there is examples of a breach of implied terms of the contract. Unilateral change in contract of service, which may include terms which are included to humiliate the employee in the hopes of making life so unbearable that they would leave. And second example being a failure to provide work. So this is because in an employment agreement, it is an implied term that as an employer, you have an obligation to provide instructions to your employees. Moving now into forced resignation and the difference here. So as I mentioned earlier, constructive dismissal is where the employee walks out himself because of a breach by the employer. Forced resignation is a bit different in the sense where it's not voluntary. The employer puts an employee under compulsion to resign, and if he declines to do, the employer would dismiss him anyway. This is also considered to be a form of unfair dismissal. So an example of how this usually occurs is when the employee is called into a meeting and they are told to resign. They are either threatened to or compelled to. When being told to resign, it is usually made clear to the employee that if he does not resign, he will be terminated anyways. With forced resignation, it is important to keep in mind that a suggestion to resign is not the same as forced resignation. Merely suggesting to an employee that you should resign does not form a threat, it's not compulsion. And if it can be shown that the employee has been given the chance to take independent advice before offering his resignation, that will also not be considered to be forced resignation. In order to decide on whether forced resignation has occurred, the court will usually look into the contents of the resignation letter and causation. So it must be proven that the reason that the resignation occurred in the first place is because they have been put under threat to do. So here, we have a quote that very nicely sums up what forced resignation is. The precise formulation by the employer is immaterial, whether it be by invitation, request, or dictation, so long as the substance of it is that the employer places his employee in a position which the employee really has no option but to tender his notice. Moving now into the case studies for forced resignation, just so we can tell the difference or really find out what the court looks into when deciding. So the first one is the case of Bata against Normadia Abu Suad. In this case, the employee had actually originally claimed for constructive dismissal and not forced resignation. The company alleged that the employee resigned willingly or the services were terminated in accordance with the letter of appointment. The company alleged that the employee had stolen company property and was informed during a meeting with the manager that she had 48 hours to settle the matter or a police report would be lodged against the employee. So in this case, it was actually considered to be forced resignation because of the fact that the way that the meeting with the employee was done, the way that the information was conveyed to her, it was a threat. As you can see here, as you can see here, either you have 48 hours to settle the matter or a police report would be lodged. The employee was also advised to resign or the company would terminate her due to a loss of reputation. So either way, she had no option, and either circumstance or situation, she would have been terminated anyways. So that amounted to forced resignation in this case. In comparison to that, in the case of Zamri Zakaria against Singer, the employee in this case owed the company because of the way that the employment agreement was actually phrased, and due to different circumstances, at the end of the day, the employee was owing the company money in the sum of 379,000. The employee entered into a settlement agreement with the company for this sum to be paid back. They had arrangements for the payments to be made back in installments. The third payment did not go through because of the fact that the check actually bounced, and the employee was called in for a meeting. The employee admitted that he could not pay the sum, tendered his resignation letter, and then the company still filed a police report against him. See, in this case, circumstances sound almost similar to the previous one, where there is a threat, there is money owing or allegations of money owing, and there is a threat of the police report being filed. But in this case, it was decided that the resignation was tendered by the claimant upon the company discovering that he could not pay the third installment and the leftover of whatever was mentioned in the settlement agreement. So he did not resign because of a threat, but rather because of his own misconduct. So in this case, it was not considered to be forced resignation. And our final case study is the case of Cheong Kok Kian against Citibank. In this case, the company carried out an investigation to employee due to customer complaints. After informing him of the investigations, the employee resigned because he had started a business without informing the company. So he was worried that in the course of their investigations of him, the company was going to find out that he had started another company, and this was actually against the terms of his employment agreement. The employee later tried to withdraw his resignation letter and then claimed that he had been forced to resign by the company. However, as mentioned earlier, the resignation needs to arise, causation needs to be shown. Resignation needs to have arisen from the threat of being terminated anyways. And in this matter, he had actually resigned because he was worried that the company would find out about his extra business. Therefore, it was not considered to be forced resignation. He stated why he was resigning, and it was an afterthought when he tried to claim for forced resignation. He had in fact resigned just to avoid the internal investigation, and therefore it would not be considered to be forced resignation. Now I will pass it over.
Hi, everybody. Before we continue with the talk, please be reminded that if you have any questions, please don't forget to type it in the Q&A chat box in Zoom. Thank you. I'll now be passing on the floor to Naveen.
Hi everyone, thank you Carolyn for that very insightful session on the cases and also the differences between forced resignation and constructive dismissal. As I move on from here, I'll be looking at case studies for cases on constructive dismissal. So with the case of Lim Win Kang against Malaysian Airlines Berhad, in this particular case, the claimant was actually a pilot and he was going for training sessions as pilots do. The company actually stopped him from going to his training sessions, and also the company had also changed his designation from being a pilot to a flight dispatcher. The claimant constituted this as a constructive dismissal and walked out of his employment. Unfortunately, the employee in question was also struggling with mental health issues. As you see, being a pilot, you're not only safeguarding the reputation of the company, you're also safeguarding the interests and lives of customers who go on board the flight. So the company could not take any risk by allowing a pilot with having mental health issues to navigate the aircraft. So with that in mind, the company actually, instead of suspending him or putting him on medical leave, actually allowed him and also afforded him the opportunity to improve his condition and also in the meantime to be a flight dispatcher. Unfortunately, the claimant did not take this into consideration and straightaway walked out of his employment by citing constructive. He failed to realize that his condition actually prevented him from carrying out his duties efficiently. The court also found in favor with the company and eventually claimed that the issue before the court was not constructive dismissal. In fact, the company had provided an avenue for the claimant to improve, but the claimant chose not to go on with that opportunity. So therefore, this was not a case of constructive dismissal. And we look at the case of Tan Cheng Hin. In this particular case, the company had reduced the employee's salary by using the common excuse whereby they were facing financial difficulties during the MCO. The employee then chose to consider himself to be constructively dismissed based on the salary deduction. And at the same time, whenever the claimant tried to confront the company with regards to his situation, the company actually told him that he can resign if he was unhappy. Now, that is not the way to go about it when you are explaining to a particular claimant. So before the court actually allowed the company to prove by bringing forth any evidence to show that they were indeed facing financial constraints. However, the company was unable to provide such evidence. The courts have actually taken sides of the company when they look at financial situations during the MCO. But however, when the company is unable to prove such financial constraints, the court eventually held in favor of the claimant and also awarded the claimant 92,000 in back wage, 92,000 ringgit in back wages and also compensation. The next is the final case study that we'll be doing today with regards to Khizr Ahmed. In this particular case, the claimant was actually being investigated for a misconduct in which he had acted in conflict of interest. And being alleged for a misconduct and also being placed under investigation, the company is allowed to put forth any measure of investigation because in the Employment Act, they are allowed to conduct due inquiry. And when it is involving conflict of interest, the employer has no other choice but to actually look into the company laptops and also surrounding his workplace and his workstation to ensure that nothing is going wrong. However, the claimant took this personally and considered it to be amounting to him being in an unsafe environment and also harassment. Before the court actually took the side of the company, whereby the employer was only doing their job by investigating the situation, and the claimant actually should not have left his employment. He should have actually waited for the investigation to conclude and to see what are the findings, instead of just walking out before the investigation was able to be concluded. So therefore, this was also not a constructive dismissal case. I'm going to now look into ways to avoid constructive dismissal and also forced resignation claims. For constructive dismissal, if we are to avoid claims, we are actually supposed to see when an employee makes any complaint against the employer, it is the employer's duty to ensure to carry out the necessary investigations. At the same time, for employees, from the side of the employer also should afford an opportunity to the employers to carry out the necessary investigation. If you don't allow the employer to carry out the necessary investigation, how are we to actually afford the company an opportunity to fix or address the issue? The company should also develop an internal complaint and investigation procedure to ensure that due inquiry is done. The reason for the words due inquiry is because this is provided by statute itself under the Employment Act. whereby due inquiry should be carried out. And at the same time, while this inquiry is being carried out, it is also important for employers to document whatever steps that they have taken to address the situation raised or the issues raised by the employee. And as you can see, it is also vital for employers to actually address the concerns and complaints when it was raised. As one of the elements for constructive dismissal is there should not be delay for the employee to leave. So in order to circumvent that delay, the employer should actually address this issue as soon as possible to avoid cases to progress to the industrial court for unfair dismissal. Then we look at forced resignation, ways to avoid these kind of claims. I think the first thing that an employer should actually look at is to consider the alternative of introducing a mutual separation scheme in the event that the employer feels that the employee should be dismissed. And the employer should also ensure that the employee is given the opportunity to change or improve their behavior. This is because if there are any misconducts or any allegations raised against the employee, an employee should be given an opportunity to improve instead of just being forced out or coerced into leaving the company. And this would also be beneficial because the employer is actually allowing the employee to improve his performance. And at the same time, in the event that they do not improve it, they can then proceed to carry out the necessary steps in conducting any dismissal, disciplinary inquiries, and subsequently dismissing the employee. And finally, in the event that an employee is deemed to be redundant, I think employers, in my personal opinion, should have a discussion with the employee instead of forcing him out due to fears of having to compensate the employee. This is the common mistake that employers sometimes do, whereby when they feel that a particular employee is deemed to be redundant, they take the step of actually forcing them out because they are worried of making the necessary payments due notice or due to the service, the amount of years that the employee has actually served the company. So this is where even a small discussion should be taking place, and these discussions should also be documented or have minutes of these discussions to ensure and to show before the industrial court that, see, as an employer, I've taken these steps to try and sort out, but I could not reach a particular outcome which is beneficial for both sides. I'm going to now look at industrial court awards with regards to forced resignation, and just to highlight how costly it has been for employers in recent years. There is this particular case of Rishindran against Lim Kok Weng. This is a particular case that actually I handled. And in this case, it was quite sad to notice that the employer in this case had actually requested the claimant repeated times to leave the company and to tender his resignation, to the extent that the employer actually asked him to type his letter of resignation in WhatsApp. So before the industrial court, taking into account all the evidence, the industrial court eventually found in favor of the claimant and awarded him 121,000 in back wages and compensation. In the case of Suzette against Lim Kok Weng, it was also similar circumstance. The claimant was forced to leave her employment to the extent that the claimant's face was actually pasted in front of the security guard booth, and eventually she was not allowed to enter into her office anymore. And the industrial court also found in favor of the claimant as she was forcefully made to resign, and she was awarded 70,000 in back wages and also compensation. And the last case that we'll be looking for forced resignation is Shafrul against Bangi Resort Hotel. In this case, the claimant was actually threatened that in the event he fails to tender his resignation, he would suffer blacklisting and his salary and annual leave would also be forfeited. This is an unfortunate circumstance as this would definitely entail in forced resignation. And the court also found in favor of the claimant, and he was awarded 106,407 ringgit in back wages and compensation. We can then also look at the cases involving constructive dismissal late in the recent months. As you can see, the case of Jimmy against BGI Global Media. This was also a case which I represented the claimant, and the claimant was actually not paid for 3 months before he actually he walked out of his employment. And after subsequent to him leaving his employment, it was only then that his 3 months of salary was then paid. And as you can guess by now, the industrial court actually favored the claimant, and he was awarded appropriately according to his monthly salary of 696,000 in back wages and compensation. As for our final case with regards to constructive dismissal for the case of Gunasekharan against FEMA Bulking Services, in this case, the claimant was actually transferred 360 kilometers away to Batuat. Transfers are often a very difficult and very delicate situation to handle. As you can see, it is very important to incorporate this into the terms of the contract of employment, whereby transfer or relocation is always subject to the employer. So it is important to state this, and when it is left out of the contract, as you can see, the claimant can actually file a case for constructive dismissal. So therefore, the industrial court also found in favor of the claimant, and he was awarded 399,960 ringgit in back wages and compensation. The reason we're highlighting these cases to show the awards and numbers of the figures that have been released by the employers to the former employees is to showcase how important it is to deal with these situations appropriately and at the beginning itself. When left untreated or when left unaddressed, these situations can actually spiral into the amounts that you're looking before your screen right now. So with that, I end my session at this point. I would like to pass the floor over to Ryan.
Hi, everybody. Thank you, Carolyn and Naveen, for your insights on the matter. We will now be taking questions from the participants in the Q&A box. The first question we have today is, what are the elements of constructive dismissal? Carolyn, could you take this?
Yep. Okay. So as you can see here just now, we presented on the elements in constructive dismissal. First, breach of contract that is sufficiently important to justify a resignation. You must leave in response to that breach of contract, and there must not be a delay in leaving because of the breach. So these four are the considerations of the court, the elements of constructive dismissal. Back to you, Ryan.
Thank you, Carolyn. The second question that we'll be taking today is, if the forced resignation is a conversation without record, how do we prove that? Naveen, could we hand this to you?
Yes, thank you. The forced resignation is a conversation without record. How do we prove that? Unfortunately, for forced resignation cases, you definitely need record of correspondence. Even WhatsApp, emails, it's always important to document this. So that is why even claimants who come to me, or employers, mostly claimants who come to me, I advise them that you need to keep this documented, even the slightest text message, WhatsApp, because you can't prove forced resignation or coercion without any particular evidence, documentary evidence, or any recording, something to just say that you were actually forcefully made to resign. So having no proof with regards to forced resignation would be a difficult claim to prove in the industrial court.
All right, thank you, Naveen. So the third question is, what does the phrase employee has a chance to seek independent advice under forced resignation mean? Is there any examples of this? I'll hand this over to you, Carolyn.
Yeah. So with regards to seeking independent advice, usually there are some cases where the employer has told the employee, okay, we suggest that you resign. As we have discussed just now, a suggestion to resign does not necessarily fulfill the requirements under forced resignation. And from there, what happens is that they will maybe tell the employee, okay, so you can take a day or two, seek advice, and usually they'll say you can get some legal advice, you can consult a lawyer, you can consult other people. Basically, just take some time to think about it. So you're given a chance to go out, leave the meeting, and seek independent advice about the matter, rather than just going forward with the resignation directly during the meeting itself, which is what actually usually happens when it comes to the court deciding that it is forced resignation. So it is any form of being able to leave, take some advice, either legal advice or speak to someone else about it. Back to you, Ryan.
Thank you so much, Carolyn. And the fourth question that we have today is, what is the proper process that the HR should have taken in the case of Bata? This one I'll pass to you, Naveen.
With regards to this Bata case, I believe that the company alleged that the employer had stolen the company property, and the claimant was also informed that she had only 48 hours to settle the matter, or a police report would be lodged against the employee. The employee was then also advised to resign, or the company would terminate her due to a loss of reputation. I think the steps that the company should have taken is to actually find out or inquire if she indeed took the laptop. And if it was a mistake, or actually she had taken it purposefully, then it was something that the company should have decided later on, instead of forcing her into resigning on her own accord and threatening her that in the event that you do not settle the matter within 48 hours, a police report would be lodged against the employee. There is no need for such threats. The fact of the matter here is whether the company conducts the necessary investigation, finds her guilty, dismisses her, and then later on files a complaint or a report or anything that you want. But you should not give them an option or coerce them into resigning. This is the common misconception that employers do. You give them a choice, and then you ask them to leave, or if not, we're going to escalate this matter or threaten them with regards to a police report. You should carry out the necessary investigations first, find out if she's actually guilty, and then see if she's guilty and go on with the next step. Not at the outset itself accusing her and also giving her only two options. As an employee, as you're all aware, employee-employer relationship is a unique one and distinct in its own self. It is more of a master-servant relationship, and there's a degree of control. So as an employer putting forth two choices, you are effectively coercing her into the choice, which is forced resignation. So a proper investigation should have been carried out, and a disciplinary process should also have been exercised in order to ensure that there were no such claims to arise later on.
Excellent, Naveen. Thank you. The next question that we have is, when an employee is asked to leave but counter proposes, could this still be a possible forced resignation? If not, what about rejecting the counter proposal? Could that amount to a forced resignation? Carolyn, could you take this?
Yeah. So in circumstances like this, there are actually cases in the industrial court where, because of the fact that there was a back and forth between the employer and the employee, there's a discussion on what is an acceptable amount or what are the terms of them leaving or resigning. Therefore, it wasn't considered as forced resignation, because forced resignation, the main thing is that you are left with no choice. You are left with no option. You are either told to resign, or if you decide not to resign, you are going to be terminated either way. So in a situation where like a discussion between an employee and then they come to a mutual agreement that this is fine, you want me to resign, these are the terms upon which I will resign, that's not considered as forced resignation any longer. If no, what about a rejection of the counter proposal? Because of the fact that it's still a discussion, if you decide not to engage in the discussion, you feel that the company is pushing the resignation on you anyways, then yes, that could be forced resignation. But it's really important to make sure that there is a proper record of any discussions that may have taken place, because later on that will be used as evidence, and the court will consider really the contents of any discussions that have occurred as well. So yeah, back to you, Ryan.
Thank you, Carolyn. Excellent. The next question that we have is, if the forced resignation conversation was done once and without recording, and then later on, the employer used a performance improvement plan to put the employee on observation for 2 months. After the 2 months, the employer then uses other reasons to condemn the employee for poor performance and makes the employee stressed and causing the employee to resign. Would this be forced resignation? Naveen, I'll hand this over to you.
Yeah, okay, so I'll take this in two parts. So the first thing that I would say, you are saying that the particular participant is saying that if the forced resignation conversation was done once and without recording, in these kind of issues, it would be always, of course, it's difficult, it's easier said than done to confirm those events by way of email or even by way of WhatsApp. Of course, you would, sometimes the other side or the employer might not know why you are confirming these things, but it's always better for you to confirm these happenings with regards to forced resignation early on. But even if it's not done, it's okay, because as I come to the second part of your question, when the employer uses the PIP to put the employee on observation for 2 months, and after the 2 months, the employer uses tons of reasons to condemn the employee on poor performance and makes the employee very stressful and resign after this. This should also be considered under forced resignation, but you have to, again, I stress, to document all these instances and all these happenings. Because if you do not, then you are left with as little to none proof at all to show that you were actually forcefully made to resign. So the important part here is to document and keep all of this, confirm it via email, all these meetings on all these events. You send an email to your HR or whoever is involved so that they know that this kind of incident happened. And if the company does not reply, it's also not a matter, because you have already sent your version of what had happened. And if the company wishes to rebut these kind of situations, they can always reply and address the issue. So it's important to keep this documented, and it would be counted as forced resignation with the required proof and documents. Thank you.
That was great. Thank you, Naveen. The next question that we have is, an unpaid leave of absence the same thing as constructive dismissal? Carolyn?
Okay, so with regards to this question, unpaid leave of absence, the same thing as constructive dismissal? Not necessarily. It really depends on why the company has placed the employee on an unpaid leave of absence. And then depending on the circumstances they're in, then can consider whether that is a breach of your employment agreement or not. So it will really depend, number one, on the reason behind the unpaid leave, and number two, on the terms of the employment agreement. However, if the unpaid leave of absence was imposed unfairly, it may, as we discussed earlier, go into breaching into the implied mutual trust and confidence between the employer and employee. So it will really depend on the circumstances surrounding the unpaid leave at the end of the day. But it's not, I would not say that it's automatic. Back to you, Ryan.
Thank you. And the next question is, how does severance pay work? And is there a deadline in the case of an employee who is considered still a full-time employee but on an unpaid leave of absence? Are they entitled to severance if they wish to quit? Naveen, could I get your insights on this?
With regards to severance pay, as long as the employer, the company is willing to payment, it's not an issue. Whether it's not an issue with regards to the status of the employee. Even if they are on an unpaid leave of absence, if the company is willing to pay before the employee actually leaves the employment because of the unpaid leave of absence, so then it's up to the employers. Not an issue for them to make the severance payment, even if they wish to quit. Yeah.
Okay, great. And the next question we have is the back payment and wages / compensation from court, a decision given by court. Is it income taxable? Could you get your insights on this?
The general rule, even by the statute, it is not taxable, because I have done cases, and most of the cases that I've done for claimants, there are no issues with regards to taxing the back wages and compensation. However, unless the chairman of the industrial court, it varies according to the chairmans in the industrial court. Some chairmans, they say that it's let's say the amount of 100,000 is to be paid to the employee post deduction or whatever taxable things, and then it's done. But some chairmen leave that out and just ask the employer to make the full payment, and in the event that the employee wants to go and report it to LLC, then they can always proceed to do that. It's up to the employee. Yeah.
All right. And the next question, is mutual separation considered as termination from the employment? Carolyn, could we get your answer?
Okay. So mutual separation is where there has been sort of discussion between employee, and basically they've come to an agreement. It's called a mutual separation scheme, mutual separation agreement. It's not really the same as termination, because termination is where the company has terminated the employment agreement, whereas mutual separation is more of mutual agreement between both the parties, and resignation, it would be where the employee leaves themselves. So it's two different matters, and claims usually come from termination, unfair dismissal, claiming for unfair dismissal, claiming for constructive dismissal. But mutual separation is where, like I mentioned, there is already an agreement, so it wouldn't be considered as termination.
Okay, thank you, Carolyn. And the next question we have is, Mr. Naveen, could you elaborate on the case study of Gunasegaran Kupusami against Firma Bulking Services Berhad on the constructive dismissal part?
With regards to Gunasegaran's case, actually it's an interesting case, because the question, Gunasegaran, the claimant, he had a few allegations of misconduct. And before his domestic inquiry, he was already given the findings of the domestic inquiry. That means the company actually, before conducting the domestic inquiry, had already provided him a letter to state that he was found guilty, and there were 3 punishments imposed on him. The first one was that he was demoted. The second one, his salary was reduced. And the third one was transferred. So you see, in these 3 instances, 2 of it are provided for in his contract of employment. Okay, in his contract of employment, it would have been stated that his position and also his salary, the amounts would have been prescribed there. However, there would have been disciplinary term which contains disciplinary actions and what would happen if he was found guilty. Unfortunately, this relocation was not part of his contract of employment. It's actually, usually it's incorporated into the contract, but however, the company left it out. So to impose such a transfer to him was definitely a fundamental breach of the term of his contract. We're talking about someone who is in the Klang Valley, and he's made to move all the way over to Batuat, Penang. So this is definitely constructive dismissal, whereby a suggestion to employers is to allow the domestic, of course, most employers do allow the domestic inquiry to conclude and then later on have whatever findings be communicated to the claimant. But in this instance, it's just that the issue was that before the domestic inquiry was conducted, he was already found to be guilty and these punishments were already imposed on him. So it differs It's more on a case-to-case basis. But this was a improper conduct on behalf of the employer.
Thank you so much, Naveen. And the next question we have is domestic inquiry. Is a domestic inquiry necessary for termination? And should we give a copy of the recording to the employee for meetings and etc.? Carolyn, I'll be passing this to you.
So domestic inquiry, whether or not domestic inquiry is necessary, it is the safest option for a company to carry out domestic inquiry anyways, give the employee a chance to explain themselves. Of course, at the end of the day, when you look at employment agreements, there is always the termination clause, and there is always the portion which says that the employer can terminate in the event that they find out that the employee has done 1, 2, or 3, whatever form of misconduct. And it's safest to carry out domestic inquiry because it proves that the company has taken steps to show or do some form of investigation to check with the employee and to carry out internal investigation at the very least. On whether such recordings of such meetings should be given to the employee or not really a reason to keep that away from the employee. Usually, most of the time, employees will ask for a copy of such recordings just to pass on to obtain any legal advice. I think that in any event, it would be fine to give a copy of such recordings to the employee. At the end of the day, domestic inquiry is more to ensure that they have taken all the necessary steps anyways.
Thank you, Carolyn. And the next question we have is, the company deducts the salary of employees without giving any time period of the deduction. The letter merely states from 1st of July 2022 until further notice. Although the employee signed the letter with objections, does this constitute constructive dismissal? Naveen?
Okay, so the question here, from what I can understand, is that company has imposed the deduction, which is taking effect from 1st of July until further notice, and the employer has signed the letter but under protest. So whether or not this constitutes constructive dismissal, I would say as it is a breach of the term of contract, a fundamental term, which is your salary. When you protest this, my advice to employees is that you give them a time period for the employer to fix and address this situation. 1 week or 1.5 weeks or 2, just to allow them and give them notice that, you see, I'm not agreeable to this. And I hope that you can repair this and address this issue and remedy this issue so that I get back the salary that I am owed. So in the event that the employer does not want to address this, you are already able to claim constructive dismissal because, as you can see, this is a fundamental term of your contract. However, employers are encouraged, before imposing these kind of salary deductions, to have discussions with the employees, to allow them to understand that, okay, you see, the company is going through a hard time. Show them and just prove to them that, yes, we are going through financial constraints, and we are most likely to have the salary reduction just for the next 3 or 6 months. To leave it hanging by just saying until further notice, you're putting an employee under a lot of hardships. You never know what, of course, the employers have their own constraints and whatever that they need to do. But at the same time, employees also have their living commitments, loans and everything. So they need to plan also accordingly. So having that discussion is so important to avoid these kind of claims. So yes, it would constitute constructive dismissal, provided that you have allowed and afforded the opportunity to the employers to repair the situation. Yes.
Okay, great. We have time for a few more questions. The next question is, if the employer wants to get rid of the employee and cooks up a reason like not being punctual and etc., and the employer then says that if the employee doesn't buck up, they will load him with more work and they will suggest for the employee to take MSS. Is this forced resignation or constructive dismissal? Carolyn?
So for this question, it looks into the behavior of the employer, wants to get rid of the employee, but cooks up a reason like not being punctual, etc., and then threatens them saying that if you don't buck up, then we'll give you more work. So we discussed the different requirements for constructive dismissal earlier. One of it was breaching the mutual trust and confidence between the employer and the employee. In this matter, based on the circumstances that have been laid out, things like basing it off not being punctual, things like saying we'll give you more work, that sounds like trying to make the employee's life so unbearable that they will want to leave, regardless of the fact that the employer is not directly saying to them, okay, we're going to terminate your contract. So in this case, it would lean more towards constructive dismissal, just because constructive dismissal also covers things like making your employee's life so unbearable that they want to go anyways. But it's important that when it comes to constructive dismissal, because of the fact that the burden is on the claimant, the burden is on the employee to prove it, you will need to ensure that you keep very good record of all of these instances, all of these different things that your employer threatens you with or does to make your life difficult. And then, of course, it's important to filter through which ones would actually be considered by the court to be breaches by the employer. I think we've been going on about this since even previously, with all the previous questions as well, just to keep very good record, keep paper trail, make sure that you have recordings, etc. when it comes to matters like this. Back to you, Ryan.
Excellent. Thank you, Carolyn. And we're running short of time, so we'll be just taking one more question. The last question would be, how does the court determine the total sum of back wages payment? If the employee is dismissed and finds another job within 2 months, can he or she still claim for back wages? Naveen, could you take this?
Yeah, okay. Again, this question has two parts in it. I'm going to answer the first part, whereby how the court determines the total sum of back wages payment. So the industrial court is allowed to make an award with regards to two headings, which is back wages and compensation. So I'm going to start with compensation first. Compensation is 1 month salary for each completed year of service. So if you worked for 2.5 years, you only get a compensation of 2 months. Like I said, you need to work a completed year of service, then you get 1 month for each completed year. So if you're 2.5 years in service, so you only get 2 months for compensation. So now we go into the back wages, where back wages is the bulk of it. So back wages is from the date of termination until the date of the industrial court award. So in cases, it varies according to when the claimant was terminated and also when the industrial court award is out. So if let's say you're terminated in the date today is 19th of October, and you eventually get an award in, let's say, 19th of October 2024. So you get 24 months. Okay. However, if the case is settled and the award comes out in 19th of October 2023, you only get 12 months. You are entitled to a maximum of 24 months, but you only get the amount in between of your date of your termination and the industrial court award. The second part of the question is, if the dismissed employee finds a job after 2 months, can she still claim for a back wage? If an employee finds a job, an alternate job, after a few months after lodging the complaint and the case is referred to the industrial court is required to take into consideration and also make a scaling down. So when you say scaling down, there's no fixed formula for it. So I've seen in most cases, it's usually 10 to 20% of a scaling down with regards to so they'll calculate the full amount of back wages and compensation. Let's say you're entitled to get 150,000. So when they make a 10 to 20%, it's to deduct from that 150,000 and subsequently you receive that award. So you are still able to get back wages, but however, it will be scaled down by the industrial court. Yeah. Back to you, Ryan.
Thank you, Naveen. That was a really great Q&A session. Now, before we conclude, I'll pass the floor back to Carolyn to go over the employment team services.
Okay. Once again, thank you so much, everybody, for joining us today. So sorry that we cannot go through all the questions, but let me just share my screen here. As you can see on the screen, these are our employment team services. We often represent both employer and employee on not just matters of dispute, not just matters of dismissal, but also, as you can see here, contracts and policies, employment share option schemes, disciplinary proceedings, performance improvement plans, medical boarding out, retrenchment, industrial court disputes, voluntary and mutual separation schemes, as well as whistleblowing. So basically, to summarize it, we can help with the drafting of any employment agreements, handbooks. We do industrial court matters as well. So if you have any questions at all, if you have any, or you're interested in engaging our services, you can just head over to our website. You can put in an inquiry. We do have a free 30-minute consultation. So this is, of course, as I mentioned, open to both employers and employees as well for any matters that you might be interested in. Thank you so much, everybody. Back to you, Ryan.
Thank you, Carolyn. Before I conclude, there are a few announcements I want to make. Firstly, please join us again for our next upcoming talk. The talk is entitled Landowners' Rights Against Trespass and Nuisance. The speakers will be our senior associates, Vivian Fan and Mr. Eric To. And secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat below. And thirdly, do follow us on all our social media accounts. We have a YouTube account, a Twitter account, Instagram account, a LinkedIn account, and a Facebook account. So basically all available social medias, we have an account. And lastly, if you would like to speak with our lawyers, we offer a free 30-minute consultation over the telephone or over video conference. Please fill in the form on our website and the link will be posted in the chat box below. Now, to all our guests who have joined us for this insightful talk, thank you for joining us, and we hope you have found today's session informative and useful. We'll see you again next time. Thank you, everybody.